terminal illness or incapacity. You can make that will so that if that happens, your wishes will be taken care of. Then there is conditional will, which becomes effective after certain condition or happenings in life. And testamentary trust will, which places assets into trust for beneficiaries. But we are talking about financial aspect. So what happens when there is no will and a person passes away? Then intestate succession applies when a person dies without a will, resulting in property division among legal heirs according to personal laws. That is Hindu Succession Act 1956 or 25. Hindu Succession Act 1956 governs the writing of a will for Hindus, including Jains, Buddhists, Sikhs. Muslims have Shariat law for Shia and Sunni, and Christian and Parsis are governed by Indian Succession Act 1925. When to write a will? This is a very important question. Ideally, you should write a will as soon as you are an adult. But many people postpone it till they are older or wealthier so that they can transfer their properties. It can be written on plain paper, no legal requirement to use stamp paper. What are the triggers? What makes you think that you should write a will? These are the triggers, or update it if you have already written. Marriage or civil partnership, birth or adoption of child, buying a property, starting a business, divorce or separation, death of beneficiary. Suppose you have written it and the beneficiary passes away, then you have to rewrite it or update it. Major life changes or health scares. If somebody gets a MI, that's that after he recovers, this is the first thing which comes in mind. What would have happened if I would have passed away? Then what would have happened to my property? Who would have been beneficiary? So that is the triggers. And when to review your will? Immediately following any of the major events listed above, or at least every 5 years, or sooner if you think so. Who can write a will? That is also a major thing. Person should not be a minor, should be of sound mind, have the capacity to understand what he is or she is doing, should not have been declared an insolvent or bankrupt. Now, coming to key components of a will. First is testator details, second is declaration of sound mind, revocation clause, asset details, beneficiary details, executor, residuary clause, guardian, signature and witness, date and place. These are the key components. Let's come to legal jargon. Testator. In law, testator is any person who makes and executes a valid will directing how his, her property and assets should be distributed after his or her death. Executor is the person appointed by testator to carry out the will's instruction after his death. They are also responsible for payment of tax, debts, obtaining probate, and transferring assets to the beneficiaries. Then revocation clause. It is a critical opening clause in a will that invalidates all prior wills and codicils, that is the extension of it, in a will, ensuring only that the current document dictates estate distribution. Then comes residuary clause. It is a critical part of the will which directs who inherits the residue or remainder portion of the estate, which is not specifically mentioned, acquired later, or forgotten after debt, taxes, and gifts are handled. This is called residuary clause. Then beneficiary details. Mind it, this is very important. It identifies specific individuals designated to inherit assets like money, property, or personal items of the testator. It is crucial to write full legal name, relationship to the testator, and clear description of estate or percentage of share assigned to each beneficiary. Asset details. Asset details will should contain in detail an itemized list of all assets, that is real estate, bank accounts, investments, jewelry, and digital assets with clear ownership details, locations, and designated beneficiary to avoid disputes later. Now, in asset details, we have the category immovable property like house, if you have a garden, if you have a farm, like those. Then bank accounts, whatever bank accounts you have. Investments, what you have done, otherwise it will go all to the state. Physical assets, which you all know, TV, etc., and all the things which are in your house. Digital assets, these are the important things, which is intangible, electronically stored files or data that hold value, that is images, videos, websites, cryptocurrencies, social media accounts, email accounts, etc. And then residual assets, which can be even after that, whatever is left. So even social media account should be transferred or should be given to other person, your beneficiary, because then that account never closes. Somebody passes away, the password remains with him or her, and you can see that account on the Facebook. I have seen my father's account, it couldn't be closed because he didn't pass the password to my to either to us or to my brother. So it is there, and it will always be there. Like declaration of sound mind. It's very important to declare before proceeding further. Medical certificate, if you are over 60 years, then attach a certificate of mental fitness to preempt any future challenges. And guardian, if the beneficiary is minor, then an adult is appointed as guardian. 2 steps to write a will: identify assets, assign shares, sign with witnesses. At least 2 witnesses should be there who are not beneficiary, and it should be signed on every page. Registration is optional but recommended as it provides legal value and validity to the will. People usually, if you go to advocates or people with lawyers, they will say that no, it is not necessary, don't get registered. But no, it is registration is very important so that your wishes are carried like that. Otherwise, people may, after all, challenge it. And draft clearly. Prerequisites to a valid will should be in writing, typed or printed is better. Each page should be signed by the testator. Revoke previous wills and codicils, that is supplement to the will. Each new will should revoke the previous wills and codicils, and should have at least 2 witnesses. Witness should not be a beneficiary, need not be on stamp paper, and validity of registered will is very high, and will can also be notarized. Hindu woman has exclusive rights on her property, which can be ancestral, self-acquired, or co-parcenary. Co-parcenary means joint. Can give self-acquired property to anyone. Can give ancestral property also to anyone. Can give co-parcenary property to anyone, but it is her share only. And that is, she can do bequest or vasiyat. Hindu male has no right on women's property or co-parcenary property, that is joint property. Can give his acquired property to anyone, can give his share of ancestral property or co-parcenary property. But if he has a child, he perhaps not give all his property, his share, because child again becomes a shareholder of the his grandparents' property. So he can't do that, and cannot give women's property to anybody. Special consideration of self-acquired versus ancestral property. Muslim law is different. In Parsi, concept of ancestral or co-parcenary property does not exist. They can bequeath without restrictions their own property, their own which they have earned. For complex problems, estate disputes, it's highly recommended to hire a legal professional to ensure full enforcement of your will. Muslim law, concept of ancestral and co-parcenary property does not exist. So bequest is limited to the extent of 1/3 of the property to anyone. It's only their earned property. And bequest in excess of 1/3 of property is invalid unless all the heirs give consent. Then only they can do it. Still there is brain teasers like probate, succession certificate, challenge, how to give effect, who is an executor, can there be more than one executor. So probate is derived from Latin word probare, to prove. It means officially proving the will is valid. And purpose of probate is to validation that confirms the genuineness of the last will, asset protection, debts and taxes are paid before transfer of asset to legal heirs, transfer of title, legally transferring ownership of assets from deceased to beneficiary, that is called transfer of title. Succession certificate, it is a legal document under Indian law granted by civil court that authorizes legal heirs to claim, transfer and manage the movable assets of a dead person who died without a will. So they need a succession certificate. So the take-home points are, a will is written to distribute property according to one's own desire after death. Any adult with sound mind and having movable, immovable, intangible property can write a will unless declared bankrupt by court. Will can be written on plain paper. It should be signed by 2 witnesses on each page and by the testator also. And details of property and beneficiary should be written in details and with clarity. So this was the end, and fir milenge, I am sure, on these topics, and especially on the financial aspect. And this is our IMSCON27, which we are hosting at Patna Menopause Society is hosting on February 19th, 20th, 21st, 2027. The theme is challenging menopause, and I invite all of you to come and to be there. So thank you. Thank you for a patient listening, and thank you for giving me this opportunity to speak about will.